Abusua ye mama kwa abasronko so de bagana politics avenue so abusua mama ye mbumra yesemu. Abusua eya chama wontumi emre bi be breaking o political highway ni so de mamu say eya ne lawyer Samuel Atachia file application bi de ko Accra High Court say eya chama wontumi eya Sama Boy mining case no aka omfa nko eya Supreme Court na mu kodi ni wo na osiki court ni say court ne mo anamfa case ne fanko ebusia nsema abetu dwa sisia ne say chema wontumi lawyer Atachia application of file court Supreme Court no Supreme Court omabo ofale court High Court no High Court omabo case no atu agu a omo say enya de a ombeso case no bi ebusia nsem no ne project dia to school ni nche de ama Sama Boy illegal mining case High Court reject Wontumi application to defer judgment and refer constitutional question to Supreme Court. Into chema Wontumi lawyer and application of file call High Court san come for assembly call Supreme Court no. Oma boy to aguma isi akofa asem kese abre chema Wontumi. Ebusia any nsemi so a kekan wa e de bebro. Mumi enkoti ye ba de jaka ebeto amoso.
Any objection to it? Is it something that we can rely on? Is it something that is authentic? So the whole thing looks bizarre. Because even in criminal civil trial, there are no surprises. In tobacco, now it has immediately for application MRI. I mean, my Lord Justice stay back for
Council.
Yes, sir.
Where the boy Metwasia Senkane any document be any doubt to be wa Sabrina prosecution no hono na defense no so e hono na wo mu dia sem maybe case management level kran bi wo wa esese afani nyina eti asem boa.
No correct. When we say section 6 of the Evidence Act, NRCD 323, I say admissibility, objection should be taken at the time the evidence is being offered.
Me ba joy section 6 na men kan is here.
Section 6 of NRCD 323.
Okay. Ba joy me kan
Ghana higher friend of the Evidence Act.
Ba joy me kan is here. Says evidence decree 1975 NRCD 323 section 6. In every action and at every stage thereof, any objection to the objections admissibility of evidence by a party affected thereby shall be made at the time the evidence is offered. Shall
Mandatory. Mandatory.
Yeah.
You know, son answer that be. I did me China you answer Makasa. Na barely. It's why me kai standing and me friend me other lawyers no because there were other accused persons and say, hey, this is what I want to do because the way I know my kono, yansheni ya yehuni. Into why ada me application me the bajaj me buy Tuesday na case me near Tuesday Thursday. Into you go Tuesday and upon 10 and upon 2 p.m. 4 hours. Into every week they are near 8 hours solid. Into me say and I say I didn't encourage me to an amount in a me 2 years. Thankfully my Lord Justice came for a court of appeal judge now. Over the wisdom in it, I'm a catcher and say, my Lord, Mr. Wu, any deal. Try ye. Yansheni ya. Young as lawyers, you may be a client in trouble. Quality legal representation is here and far more. Yes, me far more. Because section 6, I need to take an objection.
Okay,
because this is the time you are offering the evidence. Now, I am now seeing the document. It's a requirement soon I make me take a proper objection on a document I'm seeing the first time.
Na Bajawasaka says to every objection to the admissibility of evidence shall be recorded, ruled upon by the court as a matter of course.
Absolutely. Don't come in. I go back, no. My law is okay. Application here there. And then he said, look, Article 19, fair trial rules may say, an accused person should be given reasonable opportunity to prepare his defense. It is one I can't say, my Lord, with the greatest of respect. The Constitution and the use of that word, reasonable opportunity to prepare the defense, no. That prepared defense, no, a very broad concept. The European Union, this particular provision, no, the 1992 Constitution, we are taken from other statutes.
I call the 19 was all the idea because was say one no say a person charged with criminal offense.
No, the 19.2.
A person charged with criminal offense shall A. In the case of an offense other than high treason or treason, the punishment for which is death or imprisonment for life, be tried by a judge and jury.
2C.
2C, okay. Be presumed to be innocent until he is proved or has pleaded guilty.
Now Yenko D.
D. Say, be informed immediately in a language he understands and in detail of the nature of the offense charged.
Fantastic. Now G. G,
okay. Okay, G say, be afforded facilities to examine.
Wait. Be afforded what?
Facilities. To examine in person or by his lawyer the witness called by the proceeding before the court.
Afforded facilities to examine. That word, afforded facilities. You can catch the court and say, Constitution using the word afforded facilities to examine. It includes documents. Facility no yet ni pankwa. It includes documents. The examination of those documents, you know. Okay. What means for mommy to see and cast me examine? It may make us say the 1992 Constitution use of the word facilities to examine, no, it includes let me know ahead of time what you have so I can do proper examination.
And mommy surprises be in court.
The mommy surprises be two. Rakwame. Me know neko. We are buying. And I wouldn't say buying here strong, mighty. I buy no echo. Now I buy a keep it documents. Rakwame Otiaje. I buy documents, you know. And the last minute when the other spring you on me. And also the heading of that constitutional provision then fair trial. And
say na how was it? Fair trial, yes.
Fair trial. Now, how can that trial be fair? And what time or you are blindfolded me? It doesn't make sense. Even though at that time the attorney general of that time, Madam Gloria Kufu, enemy team ever court. And when I'm moving my application, almost said there be minimum crisis mechanism, no, there be the Criminal Procedure Act at 30 has only two forms of trial.
Sabrano, the whole Chief Justice in the
No, Attorney General.
Attorney General, in the case is a case of national interest, pa.
Yes, yeah, Mami Gloria Kufu. So she was in court, she was announced just that my law lecturer, my criminal procedure lecturer, Madam Evelyn Kilson, on the opposite application. So that be idea made a bano. That is not how the criminal trial system is. That be because there are two modes of trial. And
procedural, you know, the only ban defective and answer a dear baby.
No, the made a banner, that is not the law. Okay. Parliament, FRC at 30, you know, Parliament created two modes of trial. summary trial and trial on indictment. Now, say a trial on indictment, they would have disclosed the documents and the evidence they have. But because it's a summary trial, no, the Act 30 does not give them that. You know, I said, no, Act 30 was done in 1960. I'm talking about 1992 Constitution and the provisions in the 1992 Constitution. If you want me to use Act 30 as the basis to say, there is no such thing. Thankfully, the judge in question, my Lord Chebafo, saw the wisdom in what the prayer had made. If you want to look, only me arguing, but since maybe meaning Ediato Article 130, Article 19, 2G, no. And Attorney General also can say, the Americano, that is not how it is, no. That day, make I say, make us not tell me so, but Mr. Tamaklo, you do know that Article 19 is a human rights provision. So as a judge sitting here, I have the mandate under Article 33 to enforce human rights provisions. Now, Mr. My Lord, if you look carefully at Article 132, back on Article 132, then there are no. Any law. Aye,
Article 132. Me come as is here.
Article 132.
But Article 132. The what one way. Where an issue that relates to a matter or question referred to in a clause 1 of this article arises in its proceedings in a court other than the Supreme Court, that court shall stay the proceedings and refer the question of law involved to the Supreme Court for determination, and the court in which the question arose shall dispose of the case in accordance with the decision of the Supreme Court.
So that's it. And see, Article 132, they say 1992 Constitution, emma the Supreme Court exclusive original jurisdiction to interpret the Constitution. However, it can happen, say, as a so at the district court, circuit court, court of appeal, and now say at the way Senator at the High Court, what I say, or even court of appeal. Now, a combat say, there is a matter going on at the High Court, Court of Appeal, Circuit Court, District Court. Now, the parties involved, but the parties involved are raising an issue that clearly you can see that there is a genuine interpretation. High Court and now Court of Appeal are no AC, no. So, men to Anamobia, Jinawa. Nasa system no bra yen na Supreme Court for no. Na the Supreme Court interpretation sabi you at that time no. Ye de pebrewo na wetugu anamo. Bra kwame. Me kai say yen law firm. You represent Zoom Lion. Auditor General charge Zoom Lion. Say Sikabia Yetuama Zoom Lion. No, it was unlawfully paid. Into say Zoom Lion surcharge and disallowance. So in the powers of the Auditor General to surcharge and disallow. But the Audit Service Act can say Obi dissatisfied with the disallowance and surcharge, the person has a right of appeal to the High Court. It is Zoom Lion called High Court. Oko High Court, na High Court, so only in Judgement and Yaji, na disallowance near proper. So from there we appeal to the Court of Appeal. Now you do Court of Appeal, no? It is a constitutional matter at the Court of Appeal. Say, the Auditor General's power to surcharge and disallowance, no, are limited in scope. Back forth. When we made the prayer, the Court of Appeal agreed and referred the matter to the Supreme Court. That's one. Rakwame, so you say, me and me is an actor case in the man.
Sure.
So that time, Nami and Senior, Gary Nimako, a lawyer for the plaintiffs. And now, who the rates are issue here. No, we will say relief one. The relief one, no. The way or drafting no, and now or catching the relief one, no, or say the defendant within the meaning of Article 94(2)(c) is not qualified to be a member, blah 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 blah. It's even way and say, Article 94(2)(c) relief one no about as far as I'm concerned, only kicks in if the electoral commission opens nominations. At the time, Omodia said no buy, no contention in any say, when my client a registered voter.
Yes, Ebeji Chiwapa Ghana.
Within the meaning of Article 94(2)(c). And I make a dappy. Article 94(2)(c) no only comes in if the electoral commission had opened nomination, and by that time she is not a registered voter, then she is bad. Okay, yeah. And now, on for a Costa Gabra, President Rawlings appointing the first time as minister. No, he came out and said he was not a registered voter in 1992.
Yes.
And ministerial appointment was withdrawn until say 96 when no buy 96 election no buy or registered voter and Sir President Rawlings the Minister of Education or Communication later.
Yeah.
Then we can say those constitutional provisions 94 no only kicks in if nominations have been opened and the person is not qualified. But at the time, I'm senior Gary Eddie rate no buy on behalf of the plaintiffs. No. Not only the NDC internal primaries had happened. And I said no. If the issue is about being a registered voter, then there's an opportunity for limited registration. By which time she could have been registered before the electoral commission will open nomination.
It's a limited registration, but now I'm going to register, dear.
And the assassin no better no. And the call. I remember vividly. We had appeared, so the rate was before my Lord Justice Akabwafo. That time not a High Court judge, now a Supreme Court judge. In the one I mean, yes, man can call. And I'm raising preliminary legal objection. And I'm saying, my Lord, with respect, what's really one of the plaintiff case now? Also within the meaning, it means that on the interpretation they are total. And I'm saying, my Lord, as far as Article 132 is concerned, you can't hear this matter. You must stay and refer it to the Supreme Court. And Article 132 is mandatory. It says, shall stay and refer. It make us, oh, my Lord, so the American, that is not it. As a High Court judge, Mankasa. So he gave a ruling on my application. One Abrakwame, the year social right. I invoke the supervisory jurisdiction of the Supreme Court. It means invoking the supervisory jurisdiction of the Supreme Court, no. In a Supreme Court by a 4-1 majority decision. Mekai Pa, my Lord Justice Eniobwa, at that time, dissented. But the remaining 4 agreed with me. And referred the matter to themselves.
Court Barton has not departed from
no.
their earlier ruling. Yeah.
That decision, that Senator decision today has set the rule on parliamentary election contest and qualification. It was even reported in the Supreme Court of Ghana law report.
Wow.
The reason why I'm bringing all of these instances, I want you to appreciate how the Constitution and how the lower courts have operated over time. Now, There's an interesting decision by the Supreme Court of Ghana.
Kabila.
It will share the case of the Kwabena Bonfe and Attorney General 2019-2021 Supreme Court law report. This is what the Supreme Court said. The real test as to whether there is an issue of constitutional interpretation is whether the words in the constitutional provisions the court is invited to interpret are ambiguous, imprecise, unclear, and cannot be applied unless interpreted. If it were otherwise, every conceivable case may originate in the Supreme Court by stretch of human ingenuity and the manipulation of language to raise a tangible constitutional question. Practically, every justiciable issue can be spun to such a way as to embrace some tangible constitutional interpretation. Indeed, the Supreme Court in this Kwabena Bonfe and Attorney General, this is say, Sebio, a lawyer for you, very ingenious people. Omaji running very fast. Into one year, the Supreme Court will become the forum for every issue because at every point in time, lawyer need be a bit I see interpretation in it. And when the lawyer has said so, no, it means whatever the matter is happening, the judge would have to stay the matter and refer to the Supreme Court. So that is what the Supreme Court appears to be saying in the Kwabena Bonfe versus Attorney General decision. Brother, when we say the senior, and you can never take away ingenuity from senior Atachia. As
As a Jamabi, your mommy, why? DJ do me. Mommy, na yanko anim. Na afena ya kire mra no mu awie. Eti ye de ba case no ankasa wo de akoda court no. Wone wa?
But what for hini wa? What na for hini wa ni wa? What's happening? Yambo cha do.
Afena wone na suntre mu se.
Me na suntre mu se. Enya hwe mi ni anti a. Ai, wone di machi.
Na muni dia mo asuntre mu eye.
Debi o.
Esa asumbo pa.
Hey! Mi ni na suntre mu se na yenye aboni bia yenka na ya suntre mu sa asumbo.
Ai, obi bo wasuma ede. Mami sa ngomda. Kazo mema kwabo.
Kwame, asema wo kan ye no it means obi ambo wasunda. You know, obi na all kinds you the wise say you need to get your enemy closer. You know, nipa no responding say it depends on the number of enemies that you have. If you have a lot of enemies, you can't get them closer. As a Thróôws, it depends on the one or the.
Oh yeah. Now I wouldn't say SMBC Bible one. Ebe prim na meti ase enye yi.
Okay.
Odifo. Ena oka kire ne yonko difo se. Awurade ayi a kire me se bomasum. Wa bomasum a ufiri akopɛ jata bechiwo ama
we na yen sema a course of political highway so far chairman Wontumi application mo file call high court say o mo fan ko Supreme Court na ise ya bo to agum ti ende de ye ya chairman Wontumi na so ebe ye hie pa o subscribe ya no subscribe no wa share no wa hit notification bell no so am I send ba political highway so na di bia ba do ya da mase